upon the provisions of Bail Act in this 1 hour. Before getting into Bail Act, we know since CRPC deal with the bail, chapter 33 is a chapter which deal with bail from section 436 to 450. Chapter 33 of CRPC from 436 to 450 are talking about, there is the provisions talking about bail. Before getting into the provisions of bail, one thing which we should know, that is, what is the difference between bailable and non-bailable offences? So there are two types of offences you might have heard. One is known as bailable, non-bailable. Another is you might have heard cognizable, non-cognizable offences. But before entering into this, we should know these two things. What is the difference between, if I say offense in CRPC can be of two types, broader sense, cognizable and non-cognizable. Or you have also studied bailable or non-bailable. If in general term, if you try to understand, if you try to find it out, people say bailable offense, you have right to bail. In bailable offense, you have a right to bail. Where is a non-bailable offense, you don't have right to obtain bail. No right to bail. Similarly, if you try to understand cognizable offense, police have power to arrest. Power to arrest without warrant. Whereas in non-cognizable offense, police have no power to arrest. No power to arrest without warrant. This is what you know generally. Being a law student, you must be knowing this much. This is clear. My question is not this. My making of you understand is not this. I want to know how you will get to know that a particular offense is bailable or not. Does any offense which is cognizable? Try to understand. Cognizable means severe type of offense. Severe type of offense. Because police have power to arrest without warrant. Power to arrest without warrant. My question is this: how I will get to know whether a particular offense which is cognizable or non-cognizable, which of them is bailable or non-bailable? How you will get to know that a particular offense is a bailable or non-bailable? Do it mean every cognizable offense is a bailable, non-bailable offense, or every non-cognizable offense is a bailable offense? Answer is no. Try to understand these two categories, cognizable or non-cognizable, and bailable and non-bailable, are different criteria of the offense. And every time, in order to find out whether the offense is bailable or non-bailable, we will not see whether it is cognizable or non-cognizable. Rather, we have to go into schedule. So if you go your Bail Act, CRPC ke piche, if you see the Bail Act of your CRPC, you will find in that the list of the offenses given, and in that list the nature of the offense has been defined, whether bailable or not, and that list have no connection with cognizability or non-cognizability if offense related to IPC. If it is not related to IPC, yes, then it may. That is a different perspective, but our focus is upon IPC offenses. So first of all, try to understand offense can be bailable or non-bailable, and still it can be cognizable and non-cognizable. This also can be cognizable or non-cognizable. Try to understand. This is the real differential, that you can shift the chart also. You can consider cognizable offense bailable, non-bailable, non-cognizable, bailable, non-bailable. You can make that type of chart also. But any offense which is bailable does not mean it is cognizable, or does not mean it is only non-cognizable. It can be cognizable, it can be non-cognizable. Whether offense is non-cognizable, it does not mean it should be non-bailable. No, it can be bailable also, cognizable, non-cognizable also. This is the first criteria, and every time this thing, whether the offense is bailable or non-bailable, you have to see the schedule of CRP, schedule 1 of CRP in relation to IPC, and schedule 1 part B in relation to other offenses. They are not focusing about other offenses. My focus will be upon IPC. So one thing is clear: in order to know any offense to be bailable or any offense to be non-bailable, you will not. So it might be possible that offense seems to be a dacoity, uh, but it may be bailable. There may be a chance the offense seems to be a very minor offense. For example, affray, creating a nuisance in the market, but it may still be non-bailable offenses. So it is not about the severity of the offense which decide its bailability. Rather, it is the differentia created by the schedule in of IPC which will define its bailability or not. Right. Now let us go into section. So, if you see sections of bail, sections of bail is broadly divided into 3 parts. When I talk about nature of bail, if you talk about nature of bail, it is defined in 3 broader parts: bail in bailable offenses, bail in non-bailable offenses, and last is anticipatory. This is the broader perspective of nature of bail in CRPC. Anticipatory bail is something which will not be focusing, though we'll be touching this section. Our focus will be bail in non-bailable and bail in bailable offences. So anticipatory bail is something which is special right available in certain type of offences to certain courts only, right? So that is a different perspective. Bail in bailable offences is given under 436. Bail in non-bailable is given under 437, and anticipatory bail is given under 430. Other sections are from 439 to 450 are provisions of bail, how it to be bond is to be taken, what is the status of bond should be there, amount of bond should be there, forfeiture, how the reasonability of amount to be submitted to. So it talk about surety, it about talk about bail bond and everything. The main sections are 436, 437, and 438. So let us go into 436 and read 436, bail in bailable offences. 436. We start with section 436, bail in bailable offences. So, which is you have heard a general wordings or general words that bail is a right. This line that bail is a right applies directly to 436. 436 talk about such cases in which bail is a right. That means bail in a bailable offences is a right. Bail in bailable offense is right. That means magistrate cannot deny your bail. Being you practicing as an advocate or you are being a judge, you should know that in such cases in which 436 applies, magistrate cannot deny the bail except in one situation, and that is what is that one situation where the accused is not able to give the bail bond. Till the accused is not able to give the bail bond, you have authority to keep the person into your custody, else you cannot deny. So if a person whom you have been arrested is willing to give a bail, then you have to leave that person on the bail bond, though you may impose condition. That is a different thing. In bailable offenses also you may impose certain conditions, but the condition may not be arbitrary in nature. They must be reasonable, but you cannot deny the person the bail. So let us try to find out what the section 436 says. Hopefully you people have your bare act with you, because I want to give a reading and I will be explaining few words that will be very helpful for your practice and for your examination if you're practicing for preparing for any competition examination, right? So I'm reading first clause. 436 clause first. When any person other than a person accused of non-bailable offense. It simple says when a person other than accused of non-bailable offense. That means this section applies only simple. This section applies upon bailable offenses, right? Indirectly talking about bailable offenses. So this says when any person accused of non-bailable offense. That means they are trying to say in section 436 they will only be dealing with bailable offenses. Is arrested. This is arrested. Then this is detained without water. Detained without warrant. This is by the officer in charge of the police station, or appear is or brought before. Appear or brought before court. What do you mean by arrested? What do you mean by arrested? This means the word arrest means arrest by warrant. Arrest by warrant. That means police officer was having a warrant of that person. That means that person might have committed a cognizable offense. Try to understand this. This is a case of warrant. He's been arrested. Detained without warrant. That means they are talking about the case of non-cognizable offenses. Sorry, cognizable offenses. Cognizable offenses. So this is where he's having arrest warrant. Non-cognizable offenses. So or maybe cognizable also. Even cognizable offenses you can have warrant. Basically they are saying whether the police officer was having a warrant or was not having a warrant. That means they have authority to arrest you, or whether through warrant or without warrant. And next is this try to understand. This is talking about this period. Again is being arrested or detained without water. Oh, this is talking about starting 24 hours. Starting 24 hours. What do you mean by I say starting 25? Whenever a police officer arrested any person, either without warrant or with warrant, for 24 hours he have a power to keep that person into his custody. Whenever any police officer arrests any person, then under section 57 of the CRPC, police officer read with section 57 and 56, police officer have a power to detain such person into his personal custody, that is known as police custody, for a period of 24 hours. This clause, they are saying whether a person is arrested with warrant or detained without warrant. They are talking about the starting 24. Or फिर उसके बाद they are saying appear or brought before court. This is the time period after 24 hours. After 24 hours. That means he has the brought before court ka matlab that is after 24 hours. Appear means accused personally come. Appears mean accused personally appears. Try to understand what they are saying. There may be a chance that person who has committed a bailable offense is being arrested by a police officer and is into a police custody, that is without warrant, or he has been arrested with warrant as into a police custody. 2 condition. 3 condition. Third condition, that he have not been arrested and he directly appear before the court. 4th condition, he have been arrested and has been kept into custody for 24 hours, and after 24 hours it is being brought before the magistrate. In all these situations, if person is willing to give bail, this is person is willing to take bail, willing to take bail to be granted, bail to be granted. This is what 436 does not only empowers the judicial magistrate to give the bail. Even the police officer, if he found that the offense is bailable offense, then in initial 24 hours, he is entitled to take the bail from the. यही तो आप देखते हैं when you go to when you are into practice, you see police arrest few people and they make you fill some form and leave that person. They can leave that person. How they do this? Where the authority has been given to them? 436 empower them. That if you have arrested him and you find that it is 24 hours, you leave it. And you have arrested them and you have not find them or you have not left them within 24 hours, then you brought before the court. The court is entitled to leave that person on the condition that the person arrested is willing to take the bail. Nalini is asking question. He cannot be brought within 24 hours. Brought has been especially inserted denoting after 24 hour situation, right? Exactly. The word brought is being especially incorporated. Exactly, Nalini. What I am saying this only. The word brought before the court is especially used. Obviously, you can brought any person prior to 24 also, but this word brought before a court is especially signifies the situation where the police officer has not brought the accused to the magistrate within 24 hours. He may brought after 24, before 24 also. That doesn't matter. That will also fall under this brought before the court. But this situation especially signifies that situation because other two situation has been covered here, right? So this is whether you brought it to the court within 24 hours or after 24 hours, or you give it yourself. You can do it, right? When the person is willing to take the bail. I'm reading it again. I'm reading this clause again. When any person other than a person accused of offense of a non-bailable offense is arrested, we know understand arrested now, detained without warrant by any officer in charge of the police station. Now we understand this. Detained means within 24 hours they're talking. Or appears. Now appears, we understand this accused directly coming to the court. Or brought before the court. Accused is being brought before the court. It basically after 24 hours. But if before 24 hours or within 24 hours, then may also brought. This person will come into the clause of brought on, right? And is prepared anytime while is in custody of such officer or at any stage of the proceeding before such court to give bail, such person shall be released. So बोलते हैं whether within the 24 hours or after the 24 hours, before the police officer or the court, if person is willing to give the bail, you must release that person of the bail. This is mandatory. 436. That means if a person has been committed an offense of bailable offense, has been acquisition of bailable offense, then you should. If what happened, if this police officer or the magistrate has denied the bail under 436, it will turn into a illegal detention. And the writ of habeas corpus will lie against the police. Moreover, it will have a administrative action. Thirdly, it is an offense. It will amount to illegal detention. The police officer will be liable for illegal detention. If some person has been denied bail under 436, okay, without any reason, and is willing to give the bail, then it will amount to illegal detention, right? ठीक. फिर से एक बार रीड करना था. Ayush is asking me a question. Ayush has asked about what is the difference between any person and person accused in clause 1. They're saying when any person other than the person accused of a non-bailable offense. What do you mean by this? देखिए, when any person, this word any person is being used whether the police has arrested that person on the basis of suspicion, on the basis of information, on the basis of other acquisition, and other than the person accused. What do you mean by person accused? This is nothing. They're saying this person is not being charged for non-bailable offenses. So this is not they are not two different persons. They are talking about one person only. The difference is language used. Okay, it's a language used to difference, nothing else. Right? Clear, Ayush? let me do. So we are done with clause 1. Understand the clause. Let us understand clause 2. Proviso first, and then we'll go to. I'm reading the proviso. Any question? Any person having any question during the session, you can write it down. After the session, as always we do, you can ask me separately by raising your hand. Next, provided that such person or court, if he or it think fit, may and shall, if such person is indigent, is unable to furnish surety, instead of taking the bail for such person, discharge him for his executing a bond without sureties, for his appearance hereafter provided. What they're saying? They're saying while proviso says while granting bail, what you have to take? You have to take bond and surety. Bond and surety needed. Whenever bail is given, whether in a bailable offense or non-bailable offense, you have to find a bail bond and some sureties have to be submitted, right? But suppose this says any person may be released without surety also by court or police officer if find reasonable. Simple. One option is given to the police officer. They says that you should take surety or you should take bond, but there may be a condition where you find that person the bond is not required, surety is not required. You release that person on the bond, no issue. Any person, you may release in the bond. It is your discretion, but you should write the reason that why you are not taking the surety from this person. Then this proviso also use the word shall. If you see shall, this proviso also uses the word shall. So one is saying any person, they use the word may, and for the shall they use the word for indigent person. This is, but if the person is an indigent person, that means the person who is under your arrest is an indigent person. What do you mean by indigent person? Poor person. Poor. Indigent means poor. Who is poor? We will understand that. If a person is under the arrest and is a poor person, then you shall release that person. That is, now you are mandatorily bound to release that person without surety. You shall release person without surety. This is the thing. So proviso provides to discretion to the police officer or the court. This says, firstly, you should take the bond and surety. If not, then write the reason why you are not taking, and you may release the person without surety just upon the bond also. This says, this law says to the police officer and the court that even in bailable offences, though the bail is a right, you must take bond or surety. But if you find that this is an appropriate case for not taking surety, you may release the person or simply upon the bond, but you must write the reason for that. But suppose the person before you has committed a bailable offense and is an indigent person, that means poor person, then this option of not taking surety is not applicable. Rather, you are bound not to take surety, just release him on the bail bond. There is no need to ask for the surety from the indigent person, right? And who is an indigent person? For the purpose of this section 436, who is indigent person? Who is a, because every time person have to improve the prove the indigency. How you prove the indigency? This 436 solve out this problem also, and this says any person who fails to provide bail or to obtain bail within 7 days in such offences will be considered as indigent. This says any person aware of being charged for bailable offence fails to obtain bail, fails to obtain bail in 7 days, that is known as week, 1 week. Presumption is he is indigent person. What I mean to say, 436 clearly declare either you release person immediately in bailable offences by taking bond or surety, or even without surety. But if you does not release that person because he is not giving any bond or any surety, then you wait for 7 days, and within 7 days if he is able to give the surety, then it's very good. If it is not, then now you are bound to release that person without surety upon the bond only, with the presumption that this person is an indigent person. Thick. If you read the explanation of proviso, okay, what is the proviso? Where a person is unable to give bail within a week of a date of his arrest, it shall be sufficient ground for the officer or the court to presume that he is an indigent person for the purpose of this section. That for the purpose of 436, any person who fails to take the bail within 7 days or within a week from his arrest, the presumption will be raised that he is an indigent person, and now it is the duty of the court to release that person up without surety upon the bail. Try to understand. This is how you release a person in a bailable offences. So one thing is clear, that in bailable offences you have a right. That is why we say bail is a right. Why it is a bail is a right? Because this section is totally focusing how to make this person released from the custody. How? Either you police officer you per se within 24-hour release, or after 24 it is a duty of the court to release. Even if the bail bond is there, no surety is there, then still you have a discretion to release that person. Or if you want a surety and that person fails to provide the surety for next 7 days, okay, so you are bound to release that person. This is how this section is focusing to give you the more right to bail. Let us say the second part of this. 436 clause 2. This is easy. This is bailable, non-bailable offences gets over. Notwithstanding anything contained in subsection 1, where a person has failed to comply with the condition of bail bond as regard the time and a place of attendance, the court may refuse to release him on bail when the subsequent occasion of the same case he appears before the court or brought in custody, and any such refusal shall be without prejudice to the power of the court to call upon the person bound by such bond to pay the penalty thereof. What do you mean by this? 436 clause 2 is a condition upon breach of bail in bailable offences. This is if he breaches the bail in bailable offences. So suppose A is being released on bail in bailable offences. So A is on a bail. Here he got the bail. Bail is going on. Here he breaches. He breaches the bail bond. What do you mean by bail bond? Some condition has been suppose some condition has been imposed upon that. My voice is clear. Any person who is having an issue with my voice? Any person having an issue with my voice? Except Raya. Voice is clear. Okay, fine. Raya, are you hearing me right now? Great. So what this? Suppose this is a case where he obtained the bail. My voice clear now, right? Now it's clear. So we were doing, this is the situation. We were upon this situation that suppose a person is being arrested and has been released on bail in a bailable offences. So what will happen to that person? It's a case of bail in bailable offences and he breaches the bail. What this section says in such cases, if any person breaches the bail, then what happened? Second time when he applies for bail, so this is a case of breach. Now he's breaching, again arrested. It is not a same offense. It is not a different offense. Rather, it's the same offense. He have breached the bail and he has been arrested after that. Now he want bail again. This is now it's not a right. Not a right. Now it's a discretion of the court. So whenever second time in a same offense you want a bail second time, then in second time it is now it is not your right. Rather it is your discretion of the court. Now court will decide per se itself whether this person should be released on bail or not. Understand? This is how the bail in bailable offences is being obtained. Any question regarding this? Any question regarding this? Let us move into bail in non-bailable offences. Bail in non-bailable offences, right? Bail in non-bailable offences. 437. Ayush, bail in bailable offences. First time when you claim a bail, it is obviously a right, and you have to submit bail bond and surety. And second time when you breaches the bail, so whenever you breaches the bail, section 446 of CRPC imposes a penalty upon you. So first of all, upon this breach, you have to pay the penalty first, because you have breached the terms and the conditions. Secondly, now bail has not become your right. Now because you have breaches your bail, police court have an option whether to give you the bail or not, even if the offense is a bailable offense. This is what 436 says. So 436 is not saying you will not pay the penalty. So whoever breaches the bail have to pay the penalty under 446 of the CRPC. But if any person is breached the bail bond of a bailable offense, so second time when he comes for a bail, because he have breached the first bail, so obviously he have to come for a second bail. When second time he will come as a bail, he will not claim the benefit of 436. Now the benefits of 436 will not be available to him, and he cannot claim that bail as a right. Rather, now it is a discretion, and discretion, according to that discretion, court will decide. Right? Abhishek is asking a question. What is question? What happened to a person who was given surety and bond if person breaches the bail? Obviously, Abhishek, bond will get forfeited. So bond is about amount. So 446 means the penalty which you have to submit is being recovered from that bond only. What about surety? Obviously, surety also be made liable. So who has been the surety, they will also be made liable for that breach. Every person will be made liable. So there is a provision for making surety liable. They also under 446 only. They will also be made liable, right? ठीक. Anyone else? So we move into a next part. That is 437. Very important provision. Bail in non-bailable offences. So first of all, try to understand. Bail in non-bailable offences is not right. It's a discretion of the court. This is the prima facie you should know. So whenever there is a bailable, non-bailable offence, police officer cannot give you a bail. Court will give you a bail in non-bailable offences. And that too, it is the discretion of the court whether to give bail or not. and this discretion of the court is also very limited. This discretion is not available in every case. Rather, it is limited to certain cases. Even in certain other cases, there are situations, even the lower court does not have a discretion. 437 basically talk about these discretions. When a particular court have a discretion to release you on bail, and when it does not have any discretion to release you on bail. This is what 437 talk about. Let us go and read 437 and try to find out what section 437 is talking. Certain wordings are same as 436, so we will not explain those wordings again, but new wordings will be explained. Right? So I will go first, clause 1. When any person accused of or suspected of the commission of any non-bailable offences. Exactly. So any person accused of or suspected of. What do you mean by accused of? They are writing two words. Accused of or suspected of. There are two provisions of non-bailable offence. Try to understand. What do you mean by accused of? This is a name FIR. Named FIR. Someone has named this person in an FIR. He has been charged. He has been not charged. He has been accused directly. This is kya? Suspicion only. Suspicion arrest on basis of information. On basis of information. है ना? तो कहते there may be two chances that person is arrested in a non-bailable offences either because this person has been named in an FIR, that is, has been made accused in the FIR, or there may be a chances this person has not been named in the FIR, but due to some information, police on the basis of certain information, police have a suspicion upon this, have a suspected. The police have suspected him, have a suspicion upon this person, and on the basis of this suspicion, police have arrested him. Then both, either he's an MFIR or a suspected person, both have an option under 437. What they're saying, when any person accused of or suspected of commission of non-bailable offence is arrested or detained without warrant by a police officer of in charge, or appear or is brought before a court other than High Court or Court of Session, he may be released on bail. Take care. Everything is safe. This says the accused person or suspected person is brought before court or appear before court. Brought or appear before court. We understand what is brought and appear. We have understand from 36. That's same. Brought or appear before the court other than High Court or Court of Session. Try to understand. 436 is available only to 437 is all available only to judicial magistrate first class or CGM, not Court of Session. Fourth, what we are going to study, the power under 437. What we are going to study, the power of bail under 437 is not available to Court of Session or High Court. Rather, it is this provision applies. So for High Court or Court of Session, you have to go read 439. Separate power is being given under 439. The power of High Court or Court of Session to grant bail under CRPC is given under 439 or 482 of inherent power. But 437 is only available to lower courts, that is Judicial Magistrate First Class or CGM. 437 applies to Judicial Magistrate First Class or CGM. Whenever any person is brought before JM First Class or CGM, that is court lower than Court of Session, and he is suspected of a non-bailable offence, then these courts may release the person on bail. Power to release on bail. He uses the word may. This word may means court have discretion. Court have discretion whether to release Right? They are talking about the discretion of the court. So this court have a discretion whether to release this person or bail or not. May provision has been used. The latter part of this provides the capping, the barrier, uh, the stoppage on this discretion, or I will say the usage of this discretion. 437 clause 1 generally give you the discretion as a judicial magistrate first class or CGM that whenever any person who is being charged for non-bail offence appears before you or brought before you, you have a discretion that you may release such person upon the bail. But the letters part of this section, that is clause 1 ka sub clause 1, this says no person shall be released. I'm reading latter part of the 437. No person shall be released if they are appear reasonable ground for believing that he has been guilty of offence punishable with death, imprisonment of life. This is first part. This is, but court will not issue. But court cannot use its discretion if offence is punishable with death or life. This is what. So this is 437 says a CGM or JM first class. If any person come before you, you can release that person on a bail. It is your discretion. You give him, but you cannot release. They use the word shall. Clause 1 ka sub clause 1 uses the word shall. This shall is very mandate. That is, you are this shall mandate is on court. That is, court are being stopped to release any person on bail. The court are being stopped to use their discretion in the cases which the offence is punishable with death or life. So they says if you find an offence, non-bailable offence, and it is an offence which is made punishable either of a death or a life, then you will refrain yourself from giving bail to that person. Firstly, secondly, give the second situation. They give second situation. They says such person shall not be so released if such offence is cognizable and he has been previously convicted of the offence punishable with death, imprisonment for life, or imprisonment for 7 years or more. That is previous convictions. Previous conviction of cognizable offence. Cognizable offence punishable with 7 years or upward. This is second situation. Shall not release. Shall not release. Second barrier. First barrier, that the person coming before you is a person who is charged with some offense which is punishable with death or life. Do not release him. You don't have power to release him. Secondly, this person has come before you is not charged for any offense which is punishable with death or life. Rather, he is simply charged for a non-bailable offense. But this person has committed any offense previously which was cognizable offense and which was punishable from 7 years or upward, which was punishable 7 years or upward, and he was convicted in that offense. What was the conviction? That is not required. What was the conviction of the offense? That is not required. They are saying he was previously convicted or convicted of an offense in which punishment may be given from 7 years or upward. What was the punishment given to him? It is not required. It is not mandated. He was just convicted. Even a single day conviction, 1 day conviction, 2 day conviction, 3 day conviction, 1 year conviction, doesn't matter. He was convicted and convicted in an offense which can be punishable from 7 years or upward previously. And again he has come to you and he has committed again a non-bailable offense. Now you should not grant. So any previous convicted person, any previously convicted person of a cognizable offense will not be allowed to be given take bail by CGM or JM first class. This does not apply upon court of session or high court. That is a very different scenario. Court of Session, High Court have very different powers regarding bail. This 437 applies upon the lower courts. So they are creating this discretion. They are creating how the lower court will be using their right to bail. So they says you have a simple discretion. You keep giving bail. Nobody is stopping you, but do not give bail in the cases which are punishable with death or life. Firstly, secondly, do not give bail in the offences in which person was previously convicted for an offence of such a nature which was cognizable and which may be punishable from 7 years or upward. How many people have understood this? They are not saying that this person, what was you punishable for? That is not important. I have committed an offence in the past and I was convicted only for 3 months. That is enough. What magistrate does not have to see that what was the amount of conviction which I served. No, they have to see that what was the nature of the offense which I was convicted for, and what was the maximum punishment for that offense can be given. And if the nature of the offense was cognizable and the maximum punishment can be given is 7 years or upward, then this clause applies to me, and now the magistrate will not give me bail. Right? How many people understand this? But in these two conditions also, there is one chance. In these two conditions also, court may give bail. Court may give bail. That means even in these two conditions also, court have a discretion to give bail. When? Let us see the proviso. This is provided that court may direct that the person referred in clause 1 or sub clause 2 be released on bail if such person under the age of 16 years or a woman or a sick person. This is woman, sick, child under 16 years. This is if the person who is coming before you on which this proviso applies. This says if a person is the accused which is appearing before you is a person upon which these two clause applies, and that person is a woman, sick or child, then you may release him that way. Apart from these three people, you will not release any other person from the bail due to these two factors. So these two factors stop you to give the bail to any person, but they won't stop you to give the bail in the cases of women, sick, and a child under 16 years of age. Right? If they have committed an offense which is punishable with death or life, you can release them. If they have committed an offense which is previously been convicted of offense which is cognizable and punishable more than 7 years, you still can give them bail. Right? And this second have one more option, that is some special reason, some other special ground. Read the second proviso. This says provided further that court may also direct the person referred in clause 2 be released on bail if it is satisfied that it is just and proper so to do any other special reason. So special reason, that is the third, but that is applicable in clause 2 only. So these available in both three. This proviso is available in both three, but this is only in 2. So this says the judicial magistrate first class or CGM may release the person in cases of clause 2 for reason, woman, sick, child, or a special reason. Whereas in first part, that is death or life, only woman, sick, and child can release. And this is the caption created by 437. How many people have understood this? This is how you use bail provisions. Right. Apart from this, one other part very important is this, which we will be focusing upon. This is only which is to be required to be focused. Apart from this, one thing you have to keep in mind: whenever bail is given, whenever bail given under section 437, conditions are to be imposed. Conditions are to be imposed. Yes, Abhishek, I will. Conditions are to be imposed. These conditions, what are these conditions? These conditions are known as bail condition. तो बेलेबल ऑफेंस में जब भी बेल मिलेगी, नॉन बेलेबल ऑफेंस में बेल मिलेगा 437 में, तो कंडीशन इंपोज किया जाएगा. दिस इज नोन एज बेल कंडीशन. What are these conditions? For example, you will not tamper with evidences. You will not try to affect witnesses. You will be appearing to the court on certain dates. That you will be supporting the investigation, and so other conditions. So, as number of conditions as you can think, you can impose it. What do you mean by some other special grounds? Abhishek is asking me, what do you mean by other special grounds? Basically, other special grounds means, I can take up one example of the other special grounds. For example, someone is a public figure, and if such person will be kept in a in a jail for a longer period, may cause public hue and cry. He may be released on bail, and he is a person who has been convicted for a cognizable offense previously also, and he is a person who has been punished for 7 years or less than an offense which is punishable for 7 years upward. It can be public figure also. Another, some health issues also. Okay, so sick already is there. Okay, that's why I'm giving example. Special ground is one of the example is suppose some public figure is there. Another special ground is that certain, suppose he's a person who has to represent, it can be any ground. So one of the example I have just announced it because it happens in India only once. If one of the person was going to represent India internationally, and he was charged for all this, he was given bail on this special grounds. देखिए, public figure is going to tamper the evidences. Obviously, this factor will always be taken. For example, if you remember P. Chidambaram case, we see this example. The High Court of Delhi have rejected the application of P. Chidambaram anticipatory bail of application on this ground only. He being a public figure, influential figure, there is a greater chance of tampering of evidences, which later on being rejected. Application was allowed, and this argument was rejected because this is being a public figure. No doubt there is a chance of tampering of evidence. Plus, there is also a chance that due to public figure, if you try to do so, it can easily be revealed out. Okay, so both factors are to be satisfied everything. So obviously, special grounds will always be satisfied with the conditions. The conditions will be imposed. For example, upon P. Chidambaram, certain hard conditions are being imposed. So if he's a public figure and there is a chance of being tampering of evidences, so believe me, if he's into a jail, he may still tamper with the evidences. So in such conditions, you can impose more harsh conditions upon them. For example, fix the area that you cannot go beyond this area. Fix number of people which has to be visited. You have to list up the number of people we are visiting for, talking to. You can make that area so that person cannot tamper with evidences. That has been done by P. Chidambaram also. Right. This is 437. I will not read all the sections, but important is this. 437 clause 5 is very important for you all. That is known as cancellation of bail. So if bail is allowed under 437, that does not mean that you are permanently upon release now and nobody can arrest you. Under 437 clause 5, it is especially given that if you breaches the condition, or if the magistrate find it that it is not right to leave you behind outside in an open, he may cancel your bail and take you into the custody. This is known as cancellation of bail under 437. This is basic of bail, which I can make you explain. Remember always, whenever a bail application will be heard under 437, public prosecutor, court will not allow you bail until it does not hear public prosecutor. So whenever there is a bail application under 437, public prosecutors are always to be heard. An application allowing bail without hearing the public prosecutor will not be considered good, and there is a great chance of cancellation of bail. तो आप जब भी bail application 437 में जाओगे तो information 7 days notice is being given to public prosecutor, information is being served to a public prosecutor, and they will come and be here. So whenever you file a bail application under 437, court inform public prosecutor, and public prosecutor will come and defend your bail application. They will you will defend your bail application against public prosecutor. The public prosecutor will argue against your bail application, and if you satisfied the public prosecutor and the court that yes, you have right situations to be released on bail, then only the bail be granted. Okay. Any other question which you want to ask? This is basics of 437. Hope these sessions are helping you. You can ask me any questions.